Any approval may be revoked at a later date by means of a show cause hearing. The board will go through all cases set for public hearing today. After each case, the board will discuss and vote on that case. The board is vested with the power to act on these cases before us today under the Metropolitan Code section 17.40.180. The board requires 4 members of the 7-member board to be present to constitute a quorum, and we have a quorum today. The code also requires 4 affirmative votes to grant your application. In the event that there are only 4 members present and there are not 4 affirmative votes, the application shall be re-advertised for the next available public hearing. In the event there are 5 or more members present and there are not 4 affirmative votes, the case will remain on the board's agenda for the next 30 days. Applications that fail to receive 4 affirmative votes within 30 days of the public hearing shall be deemed denied by operation of law. The appellant or any aggrieved party or any aggrieved property owner may request a rehearing within 60 days of this public hearing. Further, the appellant or any aggrieved property owner may also appeal the board's decision to the Chancery Court within that same 60-day period. After that time has elapsed, the board's decision becomes final and no further action can be taken. If you are an appellant and your case is granted, it will be necessary for you to obtain the permit for which you've applied. It should be noted that a permit must be obtained within 2 years for a board's approval to remain valid. I submit that all cases have been filed in their proper order. All appellants have been notified by certified mail as required by the code. All affected property owners have been notified, and the legal ad has been published in the Tennessean as required by the code. Do we have any elected officials here today? Seeing none. Do we have any preliminary announcements? Okay. The board has a consent agenda today. A board member reviews the record on each case prior to the hearing, and if in their opinion the applicant meets the criteria for the application requested and they feel the testimony in the case would not alter the material facts, they recommend the case to the remainder of the board for approval. We will enter into the record those cases that have been recommended, and if there's anyone opposed to those cases, please raise your hand and we will remove that case from the consent agenda and it will be heard in its regular order. Mr. Whitson has been kind enough to review our agenda for today, and we have 2 cases that are slated for the consent agenda. The first case that is on the consent agenda is case number 2015-038. That is Adam Crunk, appellant, and CFR Investments, owner of the property located at 4101 Lone Oak Road, requesting a variance in the street setback. Is there anybody here in opposition to case number 38?
Possibly. I think one more.
Okay. Ma'am, what we can do is we can kick this case to the tail of the docket, and I would encourage you to get with the applicant perhaps right now and talk it over with them and see if there's a resolution there, and we'll just hold that case in abeyance for right now. The next case that we have for our consent agenda is case number 39. It is River of Life Church of God, appellant, and River of Life Church of God, the TRS owner of the property located at 224 Stewart's Ferry Pike. Is there anybody here in opposition to case 39 located on Stewart's Ferry Pike? Seeing none. Mr. Chairman, it looks like we have the case number 39 ready for the consent, and if you want to kick case 38 out, we can do that as well.
Okay, so we have a motion for consent on case 39. Is there a second?
Second.
Got a motion, got a second. All in favor?
Aye.
Any opposed? Passes.
Thank you, Mr. Chairman. Anybody that's involved with case 39, you are free to leave. Please remember that you need to come and pick up your permits starting on Monday. Okay, going to the top of the agenda, we have the first case, which I will call, it's case number 2015-009.
Mr. Herbert, aren't there some deferrals? Should we announce those in case there are people for that?
Very good, very good. Thank you. We had actually put these deferrals on the website, so as hopefully everybody knows. But case number 2015-024, Woodmont Boulevard has been deferred to May the 7th. If anybody's here on that case, it has been deferred to May the 7th. Also, case number 37, located on Nickel Lane, has also been deferred to May the 7th. Anybody here for those cases? They both will be heard at the regular meeting on May the 7th. Thank you for that, Mr. Chairman. Okay, calling the first case, case number 2015-009. This is Mr. Dwayne Cuthbertson, appellant, and Shelby Street Properties Partners, GP, owner of the property located at 1002 Lawrence Avenue, requesting variances in the side street, that's the 10th Avenue South setback in the R8 UZO district, to construct a second new single-family 2,467 square foot residence. This is referred to the board under section 17.12.030C2, 17.20.060D. The appellant has alleged that the board would have jurisdiction under 17.40.180B. We'll go ahead, Mr. Cuthbertson, if you'd like to come forward, and we'll go ahead, Mr. Harrison, and present our PowerPoint presentation. And are there any parties here in opposition to this case? Seeing none, Mr. Cuthbertson, you will have 10 minutes. And as soon as we do our PowerPoint, Mr. Harrison.
I'm sorry, Mr. Herbert, because this isn't a full rehearing, don't we need to announce or give people the option to jump in?
We do.
Okay.
Thank you.
Okay.
Thank you.
Okay.
Ms. Karpanek was not involved with the first hearings of this case. However, in the interim, she has reviewed the case record, she has watched the videos, and Ms. Karpanek, do you feel like, based upon your review, that you are prepared and can hear this case today as a voting member on the board? Okay, very good. Mr. Harrison?
All right, the property located at 1002 Lawrence Avenue. It's the corner of Lawrence and 10th. That's the existing house on the top right there that's on the property now. And those are the properties across the street on the very bottom. This is the site plan which shows there's a little dairy dip type building there to the back. It's existing. These are some signatures on a petition of support for it. These are showing setbacks of other houses that are up and down through there now. Some of them are showing different. On the left-hand side, you'll see that they range anywhere from 6 feet to 14.5 feet, I believe, 14 3/4. And here's some pictures of those houses that are referred to as far as those dimensions goes off of 10th Avenue. And these are some more houses up and down both sides of the street here that show them closer than the 20. This is where an SP zoning is, I think it's for multifamily. I'm not sure it's been built yet, but that's what they're proposing there. These are some more photographs of the properties. The top property is an existing house looking up the street, going up Lawrence, the second photo. And the third photo down is the commercial building in the rear.
Are those houses in red on 11th? Is that a connector street too, or is that I'm not sure why that.
The one on
we're
the
seeing
north
this.
is 11th and Douglas, and the one on the south is Lawrence and 11th. And that's referencing the yellow is referencing the house where they're proposing to build a second unit to the right of the existing house, and those are references showing the others how close they are to the property lines.
Right, but I'm asking if 11th and 10th are the same type of collector street. I mean, if they would have the same code requirements.
I believe they do. Because I don't think, let me see. No, let me see. Got to back it up.
I get
the Yeah.
comparison on 10th, but I'm just not sure why we were seeing the comparison on 11th also.
Yeah, I think that was just, that's been submitted by the applicant.
Okay.
I think the applicant could speak to that in his
Okay.
presentation.
And a lot of these others are showing houses in the same neighborhood that are closer than the prevailing setbacks. And this is the proposed house that would be built. And there's some references from historic. And this is the second option that Dwayne, that they have here is showing where they want to put it.
Okay, Mr. Cuthbertson, being that you've got no opposition on your case, you have 10 minutes. All you.
Mr. Chairman, members of the board, my name is Dwayne Cuthbertson. I live at 1010 Ackland Avenue, and I'm representing Shelby Street Partners. Ashley Duggar is beside me. She is one of the owners of this property seeking the variance request. Those are actually slides I put together for my presentation, so I can kind of explain why some of those images were included. But first off, I just want to say thank you for your patience with us. We've been back a few times, and you've been gracious enough to allow us to come back and present additional information for your consideration. I'd also like to point out that we are back. We started this process in December, and our first hearing was the 1st of January. And I think it's a testament to the fact that we really believe that what we're trying to do is the right thing for the neighborhood and the right thing for the property. The Neighborhood Association president is here again, and she has been here she's been to most of the meetings to support us, and I think that too reinforces the notion that the neighborhood believes that what we're seeking to do or to accomplish with this variance is the right thing for this property and for this neighborhood. So again, thank you for your patience, and I'll proceed. As Mr. Herbert noted, our request is only for a variance to reduce the side street setback along 10th Avenue from the code requirement of 20 down to 10 feet. And this is to permit the construction of a second single-family dwelling in a manner that we feel is contextual with the surrounding neighborhood. This is an older neighborhood that's composed of primarily older bungalow type or historic homes with a relatively wide presentation along the street. The code requirement of the 20-foot setback along 10th significantly narrows our building envelope and would force us to build something that we feel would be significantly out of character with the neighborhood. Again, the request to reduce the side street setback down to 10 feet, we feel is, it allows us to do something that's more contextual. And it's also important to note that we're not asking for permission to build a second dwelling on the property. The current zoning, the R8 zoning, allows us to build a second dwelling on the property. We're asking for the variance so that we can build something that fits within the context of the neighborhood. The subject property is located at the northwest corner of two neighborhood streets, Lawrence Avenue and 10th Avenue. The proposed home will front Lawrence Avenue. Its side yard will front 10th Avenue. These are two neighborhood streets. However, their designations are different. 10th Avenue is a major street according to the major collector street plan. So it, by that designation, requires a 20-foot setback. If it were a neighborhood street, or if it were designated a neighborhood street like almost every other street in this neighborhood, we wouldn't be in front of you. the code only requires a 10-foot side yard setback for just about every other corner property in this neighborhood. But because 10th Avenue is designated a major street, we've got the 20-foot setback. This property, as you can see in these images, already contains 2 historic structures. The applicants are painstakingly restoring that house. And we've been here long enough that we've seen pretty close to the finished result, and it looks really nice. They've done a great job bringing that historic home back to a remarkable condition. But you'll also notice that there is a early 20th century commercial storefront building on the northeast corner of this property. And we feel like this commercial building is an asset to the neighborhood. It's one of those elements that makes these historic neighborhoods pretty attractive. The applicants at some point intend on restoring that storefront and getting it to a place where it can once again contribute to the vibrancy of the 12 South neighborhood. So they would really like to keep that storefront. And in fact, they've received tons of feedback from neighborhood folks that they're eager to see that storefront back to a productive element in the neighborhood. So we feel like this storefront is the basis of our variance request, or our hardship, if you will. It is an extraordinary or exceptional condition. And the code, while it requires for variance, you have to consider the physical characteristics like narrowness, shallowness, the shape of the property. It also allows for the consideration of extraordinary and exceptional conditions of such property, such that it would it allows you to consider extraordinary and exceptional condition of such property that would result in a peculiar or exceptional practical difficulties. And we feel like this storefront is that exceptional condition that results in a practical difficulty in establishing a home in a manner that is contextual with the fabric of this neighborhood. So I also want to touch on, again, the major collector street plan. It's important to note that we don't feel like that this hardship is self-imposed. That storefront was constructed on this property before anybody knew what a major collector street plan was. It was constructed on that property before most of our zoning codes were ever thought of. And so when that commercial building was established on the property, there was no consideration to, well, will this reduce our footprint for a second dwelling on this subject property? It's just what they did. So it's what our applicants or our owners are left with to deal with. We don't feel like this request would result in injury to neighboring property. We've talked to all of our neighbors. In fact, all of our neighbors have essentially said, we hope you get the variance because it would result in something that we feel would better fit into what we bought into in this neighborhood. And obviously we submit that it would not harm the public welfare. It's not extending into the right-of-way. It's not going to impair sight distance on the property. It'll meet the full setback along Lawrence. And it's important to note that except for this side setback, it'll meet every other zoning code requirement, including parking. At our previous hearing, there was a concern about access and what that storefront and this home would do to access. And off of this intersection, our access point on 10th has to be set back 100 feet. That building's only at 100. That building's at 118 feet. So with our proposed footprint, which is another reason we'd had to condense this footprint, we're left with 18.9 feet to access, to put parking in behind this building. We can't access it from the alley. That's where the commercial parking is proposed for the storefront and for the house that's there today. So Rick, if you can go through some of the slides, please. Again, we've talked to many neighbors. They've all expressed support for this request. Go to the next slide. And again, the Neighborhood Association president is here to speak about the neighborhood support. There was question about the side setback, and we're proposing a 10-foot setback. This is a survey of the neighborhood going north, and all of the properties shown in green north of this house have setbacks that are within 20 feet. Some of them are within 10 feet. Some of them are at 6 feet. Rick, if you'll go to the next. This is looking south actually, these are some of the images of those homes situated closer to the street. Go to the next slide. This is looking south. These are homes that are, again, situated within 20 feet of the street setback. So what we're proposing is not unique to this neighborhood or this street, in fact. Rick, to the next slide. Here are some images. And the next slide. This is a slide that shows our relationship to an SP that was approved by the Metro Council several years back. It proposes, it was a reuse of a storefront. That storefront's now gone, but it permits a 45-foot tall mixed-use building right up on the street. So there was question about how we might interrupt some sort of pattern in this SP, along with our request, along with a lot of those examples north and south of the property, kind of set up that pattern already along 10th.
Can you go back to the previous slide? That lower left-hand picture of the two houses, it looks like it's a fairly new construction. Did that have do you know, is there any record if that has a variance to it, or how did the southeast corner 10th, and I can't read because of the blue, that lower left?
10th and Gilmore.
It is 10th and Gilmore. That's right.
See, that one right there. I mean, it looks like a fairly new one. I'm just asking if any of the codes folks know how that one came about.
I looked it up. No.
It is a brand new, it looks to be less than 10 years old.
I don't think it came in front of this board for any variances, so it must be code compliant.
Well, Mr. Harrison, can you move on to the next slides? This is an image that was attached to that SP to show that we're not talking about an insignificant building that would be constructed on that SP. Rick? Here are some examples of side streets. There was also concern about interrupting the mid-block pattern. Side street yards were shallower than those found in the interior block. And in fact, in this block, there are 4 houses, keep going, Rick, that are closer than the interior setbacks. The average width on our block is 36 feet. We're asking for the variance so that we can build something, again, contextual with that width. Okay? Here are examples throughout the neighborhood looking north of the site that also have setbacks, side setbacks that are shallower, much shallower in some cases than the prevailing setback along that block. And Rick, looking south, some examples, again, they're pretty prevalent through the neighborhood, okay? Here's an example of our house that we're proposing to build. Obviously, the image is distorted. And there's an image of the house that is a similar model to the house that they're proposing constructed in a historic district, one that historic.
How close are the two houses going to be?
They're going to meet the code's 6 feet of separation.
Do we have any other questions?
Maybe I'm still confused, and I'm not necessarily opposed to the setback of 10 feet. What I don't understand is how does the building in the back play into the hardship, the old thing?
If we feel like if the commercial building was not there, then we would have access and we would have depth that we could gain, and so this house could remain 2 stories, and we would get a house that we felt was contextual. Again, we're not dealing with access challenges at that point. This commercial building, it really limits our approach for vehicular parking on site, and it constricts our ability to go deeper with the house.
So does that in reality play into the side entrance into the garage from the street?
I don't believe there's proposed to be a garage. It's just going to be driveway parking behind the house at this point. And
Am I misreading something?
there was some concern or confusion early on. When we made the application, we never really covered whether we'd have garage parking, and I think the zoning examiner assumed that we would, and so he signed us up for that variance of the garage facing a side street. And all along, we've submitted that we're not asking for that. So we're not proposing, and you can see in this image, the side elevation that will face 10th. We're not proposing a garage, because I just think with the volume of traffic on 10th, it would cause more problems than it would solve in terms of.
So we can strike the garage door facing the side?
Yes,
comes
sir.
off the-
Yes, sir.
Okay.
So all of this it's still one property, correct?
Yes, all one property.
So if there's one owner, I don't understand why you can't use the parking for the house that's behind the commercial building.
Well, when that commercial building is restored, there's on-street parking on 10th, but to the extent that we can bring employees behind the house and provide at least if not two, customer parking spaces behind that commercial building, I think that sort of scenario would be looked on more favorably by the neighborhood and possibly by future tenants. But also, we've got to get parking back there for the existing house on the site. So it's not just customer parking, it's also homeowner parking for the existing house. And to snake parking for this proposed house through that parking lot and down and around, it just seems very problematic. Mr. Harrison, if you can find the slide with the site plan, that might help. It's early on. That might help. Oh, there it is. So obviously the slide's a little bit distorted, but we've got, in terms of 10th, this building's 118 feet off. And you can see the back porch for the existing house. It would be more than tight to try to snake on off-street parking in from the alley and still provide adequate parking for the tenants of the commercial building customers and the homeowners of the existing building.
There were alternative elevations at the beginning of the presentation. Can you address those?
That was an option that we felt like if we had protest, if at any point we felt like there were neighbors who just couldn't live with 10 feet, then we thought maybe there was some sort of compromise. But again, looking at the average width along that block, we're still not meeting it with this 10-foot variance. But I mean, we're in that 30s range, so it's 3 feet off, but we feel like the 10-foot variance would get us to a point where it just kind of fits within that pattern on 10th.
What was the width of the fronts of the alternative house?
It
looks
was
like
it was reduced by 5 feet.
by 5, okay.
Yeah, which made it narrower looking for sure.
So on the 50 feet of the side of the house, are you in that 10 feet, extra 10 feet you're asking for that's all house?
I'm sorry, I'm not sure.
So if you were to draw the 20-foot setback on here,
Yes.
and you're asking for a 10-foot setback, you're building all the way to the 10-foot setback. So I'm guessing that means you have 500 square feet in the footprint. 50 feet times the 10 feet.
Well, and it would be 2 stories.
Okay.
And I would also point out that we have to meet the front setback on Lawrence, and that's right at 30 feet. So that pushes the house back a fair bit. Front setbacks in that neighborhood vary wildly. Some are as close as 10 feet. This block, the average is right at 30.
And what did you say the average side setback was on the comparables that you gave us?
I didn't really run an average per se. I gave just the numbers. They range from, I know the house right at the corner of Ackland and 10th is at 6 feet. The one at Bate and 10th, I believe that's at 14 feet. but every one of those that's highlighted in green is within 20 feet. They have shallow setbacks. The ones on this block, and you're right, 11th is a different kind of street, but it's representative of the pattern on 11th and Douglas and 11th and Lawrence. Those are as close as 6 feet.
Okay.
Do we have any other questions?
Well, I just want to be sure that, and I like your plan and I can support your plan, except I'm confused about the building being the hardship, and I just don't see that building being the hardship. If somebody can help me there, I could use some help. That old building I'm talking about.
Sure. And maybe legal can help expand on this, but the code requires, my reading of the code at least, requires that in order to obtain a variance, you have to consider the physical characteristics of the property, such as narrowness, shallowness, shape. But it goes on, and I'm not a BZA expert, but I don't hear this used very often, but it goes on and says that in order to obtain a variance, you can also consider other extraordinary and exceptional conditions. And we feel like the storefront that was built in the early 1900s is pretty exceptional, and it's unique to this property. While we do have a collection of storefronts in our older neighborhoods, they're still very rare that you find them and that they're usable in some cases.
I agree, and I guess my concern or question is, if that old building weren't there, would you have a hardship?
Well, if that old building weren't there, I'm not sure that we'd be here. I don't know that we would. I think then we'd have the depth and we'd have the access off the alley. And I think, I'll say this, I would think most neighbors, certainly the ones that we've been in contact with, and the neighborhood president might be able to expand on this, would still rather us be here asking for a variance so that we can do something contextual that fits within the neighborhood. And in fact, I think if we have to build this 23-foot wide house at 3 stories, we're going to upset some people.
Yeah, don't get me wrong, I don't support the tall skinnies either,
Yeah.
so.
It took me a while to figure this out, so this is my translation of what they're saying is, if they could, they would come off the alley to get their parking, but they can't because they can't go through that building. Right. So they got to bring the parking off of 10th, which means their building can't go further back. And so the building's, this is my word, stubbier than it would be. But for that building, they would have greater ability to go backwards. Believe me, it took me like 2 meetings to figure that out.
And the length of the house versus the width is what you're saying.
Right.
Okay.
Are we done with questions, or, I mean, okay, then we're going to move to close the public hearing and open debate.
Mr. Chairman, did you want to hear from the neighborhood association?
We're out of
You
time.
don't have to.
I do believe we're out of time, but we know you're in support, correct? I mean, support. In fact, would everybody in support raise their hand? Okay, thank you. All right, opening debate.
I would say start off on day one, because I guess maybe I didn't understand the purpose of the old building back there, or that is a variance, but since had some light spread on the subject there, I'm really not opposed to it. So.
And I had a tough time the first time we heard it with the hardship. I know we asked a lot of questions, and I applaud the applicant for what I consider to be extraordinarily thorough homework in terms of getting information, examples. I know we're looking at the property as having an extraordinary situation with the retail, but I think that the examples on the street are also, I think, part of an extraordinary situation where it might not make sense. And, you know, if it were me and my property, I would, I think it'd be fine. I'd love to see a little more space between the two houses, and, I don't know that they have asked for that for a narrower variance, but I think if it's headed that way, I'd almost prefer an 8-foot variance with a 8-foot requirement between the houses, but knowing that the context on the street supports that, but that I can support the request.
This is a smaller matter, but this is also the best use of smiley faces we've ever had at BZA. This is perfectly effective smiley faces. So.
Well done. And the smiley faces, of course, represent all the door knocking that you did and support of your neighbors. You were very thorough. I didn't have a problem with this at first. I commend you for your efforts to save one of our old storefront buildings. We used to have a lot of small buildings, stores, schools, and such, and this is kind of a throwback to a different time in Nashville, so I'm glad that this will not be torn down during this.
Second that. Support that old salvage, that old building. I guess your real hardship was my misunderstanding of what was going on.
All right, I'm going to move that the board approve the variance because all of the requirements of MCL 17.40.370 have been met. The board finds that the unique characteristics of the property are the extraordinary and exceptional condition of the old storefront building on the back that limits depth for the requested variance. Is there a second?
I'll second it, but I only had a caveat on that. I think we need to strike from the application about the side garage door facing the street.
Okay, I agree. So got a motion, got a second, all in favor? Aye. Any opposed? Passes.
Good luck. Thank you for
you all.
coming back.
Patience counts, right?
Mr. Woodson, would you like to revisit the consent agenda?
Indeed.
I understand that the case number 38, that they have reached a resolution. There's no further opposition to that case, and they'd like to have it roll back onto the consent.
Okay, so I'm sorry, we have a motion for 38 to be on the consent agenda. Is there a second?
I'll second it.
Got a motion, got a second? Oh, I'm sorry.
Actually, you could just, since the consent agenda has already been approved, is my.
Oh, thank you.
Okay, I'm sorry. Since the consent agenda has already been approved, you can just move to approve this application if that's your desire, rather than putting it on the consent agenda, because technically it's already been passed on.
Okay, so I make a motion to approve the requested variance in case 38. Is there a second?
Second.
Got a motion, got a second. All in favor?
Aye.
Aye. Any opposed? Passes.
Okay, moving to our last case to be heard today, and that'll be case number 2015-035. This case is Eric Mallow, appellant, and Leslie Brown, owner of the property located at 477 Chestnut Street, requesting an item D in the IR district to construct a 320-square-foot addition to the side of the non-conforming residence. This is referred to the board under 1740-660C. The appellant has alleged the board would have jurisdiction under 1740-180D. Folks, what we'll do is we'll have Mr. Harrison make our presentation, and then we'll turn it over to you. And do we have any opposition on this case? We do have opposition. Are there any preliminary announcements on this? Because the department and staff had heard that there may be a request for a continuance. Is that the case or not?
Yes, we sent a lawyer in. We brought the letter from our attorney stating that we were in dispute over a previous to where they had added on to the house, and it is actually in question as to whether or not it's on our, over the property line. So
Okay, so do you, are you going to be asking the board, because as a preliminary matter, are you going to be asking the board to continue this case, or do you want to go ahead and hear it in its full in order?
like for continuing.
Why would that have a bearing on the continuance of what we do today, I guess?
There's a dispute who owns the property, including where the proposed addition will be constructed.
Well,
That's not true, sir.
hold on, just one second. For our attorney and our sergeant at arms, apparently. Nice pickup there. Should we hear the merits of continuing before this?
That would be my advice to the board, is to hold a hearing on the issue solely of the deferral. If there's a deferral request, then the applicant can show why it should not be deferred without getting into the merits of the actual case, and then the opponents can have an opportunity to show why it should be deferred, and then the board can make the threshold decision on whether it should be deferred. After that decision is made, then you can actually make a decision on the merits, depending on what you rule.
And to further muddy those waters, I don't know if this applicant is prepared to argue for or against the continuance.
Well,
under the merits of the preliminary hearing that we're talking about.
And I think they've heard a little bit about what the argument is going to be just by Mr. Herbert asking them what they intend to argue. So I think that they are at least able to, and I can't speak for the applicant. I guess you would have to ask the applicant, are they ready to deal
Right, and I
with
just
that
wanted to say
issue?
that might be an issue that we might have to defer to the
Right, are they prepared to
Right.
discuss whether or not it should be deferred, and whether or not, and really, from a legal standpoint, the issue is whether it's relevant that there is an ongoing property dispute. It may or may not be relevant, and the court, I'm sorry, the board, I promoted you all to court. The board may feel that it is relevant, or that it is, or that is not, to the decision that's before them as to whether or not they are granted the appeal that they're seeking or not. So there's some preliminary things that need to be decided by the board, I would advise.
So the opponents have asked, is it a one-meeting deferral till May 7th?
Well, I think what we ought to do is have the entity that's making the motion for the deferral to come up and make that motion and present their evidence, and then the opposition can then state their evidence, and then you all can make a determination as to whether it should be deferred or not. And then we take up, if you do grant the deferral, then to when.
I agree.
So I guess, so folks, if you don't mind, since you are the persons who are making the motion to defer, if you would mind coming forward and make that motion to the board. And folks, when you do, if you would, please turn your microphones and identify yourself to the board, please.
My name is Kirk Francis. Okay, sorry. My name is Kirk Francis. I am the owner of the commercial property next door to the building in question. We're at 467 and 469 Chestnut Street. Our property is basically right next door to the house. Ours is commercial and theirs is a residential home.
Can I ask you a question? We have a letter from Watkins and McNeely, a law firm representing you on this matter. Is there a reason why they're not here today or couldn't be here today?
Well, they were going to come to this, and we thought that we were just going to be able to get a deferment. We can certainly involve them if that's necessary, but we've done extensive research through their firm to, well, it's a long story, but to figure out the whole situation, we've already spent quite a bit of money to try to get to the facts of this matter, and we just thought that we could handle the explanation of why we wanted the deferment, and then if we needed to get them involved as well, we can do that.
I noticed from their letter that there's currently a survey being done.
Yes.
When do you anticipate the results of that survey?
Well, the truth is, we had one survey done because we added a warehouse onto our current building, and that warehouse is completed. But this is when the red flag threw up last year, back in the summer of 2014, when they had the survey done, or whenever that was completed. And we tried to request that we negotiate this, but I don't think that they have ever gotten a legitimate survey. We've requested that they have one instead of a site plan. They don't have a survey. So we decided to go ahead and get a more in-depth survey from James and Associates, which is an engineering and survey firm. So this would be our second survey. And they actually just completed a preliminary sketch drawing yesterday. We didn't think it would be done before this hearing, but they surprised us and had the information for us last night.
Well, I guess I'm trying to figure out, when will they certify the survey? Because
Is it certified?
It is stamped.
It's stamped.
It is certified.
Okay, it is?
Yes, we were still in the process of negotiating because we wanted our lawyer to talk to their lawyer and try to work through the situation we have before this went on any further into another.
But we cannot place, my name is Julie Thompson, I work for Mr. Francis. We cannot place their addition onto our survey because their site plan didn't have all the dimensions on it in order to accurately place it on our survey.
So are you saying that that your concern is that the addition that they're requesting now
Yes.
will be infringe on your property, or existing pieces of their structure are now on your property?
Yes.
Yes,
So both of those?
yes.
Let me ask, have you presented this new survey to the owners of the property?
We haven't had the chance. We just got it last night. This morning, we talked to our attorney. We also discussed the survey with the engineers and the surveyors who did this more extensive survey, but it's all happening right now. We just got this information.
Okay. Well, just thinking off the top of my head, I'm going to be really reticent to vote on anything where it could possibly go over a property line. And so deferral seems like the only reasonable thing to do. I mean, I'll be glad to hear you, ma'am, but if there's a survey that either says you are going over or you aren't going over, that really puts this board in a tough situation. I think to me, it makes a lot of sense to give them a couple of weeks. But I don't mean to speak for you, so.
And I think the other thing the applicant said was they couldn't necessarily tell because your plans were not necessarily in the final form where the addition is exactly going.
Well, I can address that. Our warehouse is completed. We actually built
I'm talking about their
Oh,
plans.
I'm sorry.
Their plans. So if you don't know exactly where their addition is going, it's hard to say if it's going to encroach or not.
Okay. Does anybody on the board or do you have anything else to say? Because if not, I mean, I think we ought to let the applicant speak. Does anybody else have anything? Or
Do you have anything?
no?
I have a question. Will the survey include their house and will it include their current house in the current condition on your survey?
Yes, we have it. The survey that was just done, the more extensive survey, shows their house, and it goes all the way back to the early 1800s. I mean, this is.
Well, may we see the survey, and have you
Sure.
shown the appellants
You have
the
copies.
survey?
I have copies if you'd like to see those.
We've got
Would you
the
mind
more-
sharing a copy with them while we look at it just for a
Sure.
second?
This is the one we just got. Really, I just saw it this morning.
Chairman, do you want to
Yeah,
hear from the others?
in an attempt to move this on, thank you very much, and can we get y'all to come forward?
Thank you for hearing.
And if you guys could each give your name too, so we have it on record and we know who you are.
I'm Eric Malo. I'm here on behalf of my friends and clients, Lauren Brown and John Sewell.
I'm Lauren Brown, the property owner.
John Sewell, husband.
I mean, I don't think anybody, certainly this board, I don't even think the opposition, anybody's trying to sandbag you. I mean, if I just got handed a survey, I would want time to digest it.
I mean, I could answer one thing right now. It's wrong. Their frontage on Humphrey Street by their deed is only 44.6 feet or something thereabout, and here they're showing almost 51 feet.
Are you an engineer?
No, but I've helped do surveys, and I work in AutoCAD all the time. And I'm aware of this issue because, sorry, I'm nervous. They've approached us with another survey before that was also in error.
So you're saying
if I'm reading it correctly, they have 50.77 feet, and that's not what their deed shows that they own.
So there could be a conflict in.
This would be the second
deed.
survey. They have had a problem with their deed before. This would be the second survey that's.
So have you ever had the property surveyed, your property?
We have not, no.
And how long have you owned the property?
I bought it in 2006, and then we put it in Lauren's name, Leslie Lauren Brown, in 2008.
In addressing the request for continuance, is there a downside to us continuing the case to a meeting so that we can determine if their survey is correct? I mean, their survey is certified. It may give you the opportunity to speak to your own expert.
Sure, yeah, their last one was certified too.
Or, if you dispute this survey, then I think the best thing to do is to come to us next time with your own survey by someone who's willing to stamp and sign off on it.
Okay, yeah, I guess the addition we're requesting, it does not seem that it seems like it'd still be on our lot, and I guess we're expecting an addition to our family. So that's kind of the nature of our request, is to try to have this small addition done in time for the little one.
Well, we understand the urgency of that,
would be,
certainly, but
right.
I think if we deferred to the next meeting, when would that be, Mr. Herbert?
May 7th.
I'm sorry?
May 7th.
Could I also just add a little bit of context? That part of the concern for me as the owner, and obviously as a person expecting, is that as you can see, there's a lot of history here, and it's a little emotional on our side because things I won't say because it would be probably libellous, because it is a legal situation with them. But this has been difficult, and my concern is that they had a survey. We found a scrivener's error and determined that it was not accurate. We had a survey that showed it was not accurate, and now they're producing yet another. And my concern is, how long is that process of back and forth going to go on between different surveys, agreeing and disagreeing?
Well, I guess, let me just help you, or try to help you. I don't think any of us are saying this survey's correct. The problem for us is we're a quasi-judicial board, and we've got a certified survey in front of us that's evidence, and it's the only evidence we have at this point. And one of the conditions to the variance is there'll be no injury to the neighboring property, and I don't know how any of us could vote. And so I think it's really in your best interests. And believe me, I'm not jumping to their side. I'm just saying they have evidence and they've put it in the record, and this is new to you, and that's, from where I sit, a little bit unfair. Not that y'all are trying to be unfair. It's just, it's the timing's unfair.
So if we would have brought our survey that shows that it's different than this, would that have been evidence in support of us?
I think that's helpful to me, and, it's also, from what I see from what you're proposing and what I see from even their survey, I'm not sure that there's an overlap. There may be a setback issue that would impact your addition a little bit, and in terms of the type of appeal that you're requesting, and, then an item D, that just says you have a non-conforming piece of property, and is this going to be more or less non-conforming? It's residence to residence. I mean, usually this is not a difficult situation for us to say, okay, as long as you meet the other codes. But when there is this dispute, then it is probably important. And so if you don't have kind of grievous injury for a 3-week deferral, I think that probably a really...
Could I follow up to that too, just with 2 brief questions? One being is if John and Lauren get a survey that's certified that supports the site plan that we've drawn and the research John has done, and therefore is different than the opposition's, what would happen in that case if we brought that to you?
Well, we would have to review the evidence, and, it's not uncommon for opposing expert testimony or evidence to be given to answer that question. But I will say, and I'm not advising you one way or the other, you should be aware that, we're being asked to decide in this case a variance that if the case itself is challenged, not only could our decision be overturned and further delay you, just by the nature of this dispute, if something is found in error with one of the property lines, or there's some disagreement, and someone above us, court decides that, okay, well, here's the problem, we would have to rehear the case. So it could potentially even more prolong things. That's all worst case. Our feeling, I think, is, as always, is see if you can work this out. Let's get the surveys together, figure out. I'm sure the surveyors on either side, they have no dog in the fight. They want it to be right. That's their business, and they're not out to take land from you or take land from them. Everybody wants it to be right, and it could do serious harm to what you think a decision you think you have, because we've made a decision based on faulty evidence or something like that.
The other question I was going to ask is, based on our preliminary review of this, the addition may not even go over the setback based on that property line. If that's the case, and we come back with a revised site plan with what's shown on that survey, and it's within the setbacks, could we then be heard again under those conditions and move forward, not to consider some of the other concerns that the opposition may have?
Is that a question for our legal counsel? I mean, if there's a property dispute, but the addition has, is within the setback of, the worst case scenario. I mean, if it's still within that setback of, like, say, if the opponents say the property line is closer to their house than they say it is, and the addition's setback is within the opponent's surveys, could we just say, you're fine, and that disputes between y'all is separate from what we're talking about?
I hate to do this to you, but can you repeat that? I'm
Well,
not sure I follow you.
Well, you got to. I'm sorry. Yeah, that didn't make any sense when I was talking. I thought, God, you're not making any sense. Well, no. Here's the thing. I guess. All right. So if they come back next time, you've got 2 opposing surveys. One's here and one's here. Mm-hmm. This is theirs. This is the opponent's. Here's their house, and their addition would meet the building code setback within the opponent's survey. Mm-hmm. Then, do we have a dog in we don't have a dog in the property line dispute? I mean, we're saying even
right.
in both surveys, you meet the setbacks. So that is y'all's business. to deal with however you
Correct.
deal with.
I would agree with that.
Okay, so if you do come back then with a plan that is within their survey, then we wouldn't have a deferral.
Correct.
But if you feel like you need to have that space, then you need to get your own survey and say, well, ours is right, and they can say, well, no, theirs is right, and then that may cost you more time too. I don't know.
I think so, but I think all we're doing today is it may or may not be that your addition has anything to do with this particular boundary line that we're talking about. But we're not determining the relevance of that at this point. I believe, I don't want to speak for all of the board members, we're going to agree to defer this. I recommend that if you're going to get a survey, you share it with the other side before we come back, so that you do not further delay, so that we have the ability at that point to determine if it's going to impact your variance or not.
I remember a case we had, the garage thing, remember that had the overhang? And the neighbor said it was over their property. We heard that case, but we don't approve encroaching on another property. I don't see us as we would be doing that if we heard this case here. It's up to the property owner to be in compliance with the property line setbacks or whatever. I almost feel like we should hear the case.
No, but as Chris pointed out, in our rules, if it affects the neighboring property in an injurious way, that's part of our consideration, and I don't think we can determine that today based on one survey.
Why not?
The question would be if they said, we don't agree with this survey, but we will build within the code's parameters of this survey, then it couldn't be injurious to the neighbor.
Right.
But hold on, I think the only real evidence in front of us is the opponent's testimony that they couldn't figure the dimensions to see whether it went on to their property or not. And so the only testimony we have is that we don't know. And so I just feel like we're doing everybody an injustice by moving this quickly. I mean, it's just, y'all need a survey to match their survey. And to your point, it would be great if the surveyors could work out any issues, because of the 7 of us, there's not a surveyor in the group. And so if we come up with competing surveys, it's going to be tough for the 7
Or
of
if the
us.
surveyors could agree,
Yes.
if something is in dispute, that it's in dispute, and that's our professional opinion, we disagree.
Right.
That's fine, but we will only have one side of the survey issue, and I think that does go to the injurious issue.
Yeah. So, applicant, I hate to do this to you, but I'm almost trying to do it for your own good. I'm going to move for a deferral until May 7. Is there a second?
I'll second.
Got a motion, got a second. All in favor? Any opposed? Okay. Passes.
Thank you for your time.
And that will conclude our Board of Zoning Appeals for today. Thank you.